All right, we'll go ahead and get started here. Good morning, everyone. I'm Anthony Lyons from SMART. Brian's had a last-minute schedule change, so I'm stepping in to fill in for his shoes, so that's why you don't hear Brian's voice on the other end. As mentioned just a moment ago, we have Julie from Scott & Scott here, and we're going to be talking about successfully defending against software audits, something that's becoming more and more prevalent nowadays, and we're seeing requests from Microsoft and a lot of the other license providers on a more frequent basis. And Julie's here to help go through and talk about that in a little bit more detail and provide some expertise on that as well. I know we rely on them and lean on them a lot of times when customers are going through these audit process. So Julie, are you there with us?
I am here. Can you hear me okay, Anthony?
I can hear you just fine.
Excellent. Would it be possible for you to change the presenter so that I could control the slides?
Yes, I will go ahead and do that now.
Excellent. Thank you so much, Anthony.
Not a problem.
I'm going to go ahead and get started because we have about 30 minutes to get through a lot of information. And so I want to make sure that we have plenty of time to cover everything. So my name is Julie Mockel-Folks. I'm a partner here at Scott & Scott Law Firm. I am based out of Dallas, Texas, and I have been working with the fellows at Smart IT for a number of years. And I'm actually having trouble, Anthony, getting the slides to show up on my screen. So if you'd like, I can just, and you don't mind, I could just ask you to change the slides as we go.
Sure, yeah, why don't we, I'm going to go ahead and if you could make me the presenter again, and then I'll...
Okay, I absolutely can.
And then I'll just click through that.
Okay, perfect. Thank you so much. I'm sorry to be such trouble. Okay, so we're going to talk today about successfully defending software audits. If you could flip to the agenda, Anthony, that would be great. One of the things that I want to cover is who is likely to audit, and then what some of the legal issues are, many of the mistakes that folks often commit when they're responding to software audits, and then what a typical audit defense process should look like but usually doesn't. We can move on to the next slide. So the types of software audits are audits that are initiated by the publisher themselves. So that's Microsoft, Adobe, Oracle, IBM, those kind of audits. Many of the people on this call may have already experienced a software audit by one of these companies. If you haven't, it is more likely than not that you will, because Gartner says that most companies have been audited by at least one software publisher at this point, and if they haven't been audited by anybody, they're going to be. There are many publisher-initiated audits that are actually outsourced to the auditing accounting firms, so Ernst & Young, KPMG, Deloitte. Those auditing firms have a robust practice assisting auditing software publishers with their audits. They try to give you the appearance that they are independent, and that's what, for instance, Microsoft or IBM would tell you. We picked KPMG because they're independent, but what you'll find is that their independence maybe has a different definition than the one that you might be familiar with. And then finally, we have audits that aren't really audits at all. These are very high-pressured audits from some of the larger software publishers where they say, we want to help you. We want to help you establish a robust software asset management practice in your environment, and so let us help you, let us pay for it. There are also some third-party audits that you might face. These are audits that are initiated by trade associations that are paid by some of the larger software publishers to make sure that the customers are compliant, and these are typically initiated by either the Business Software Alliance or the Software and Information Industry Association. You can switch to the next slide, please. So let's talk about the publisher and the third-party audits. Why do the publishers have the ability to audit you at all? Typically, it's because if you're using those products, for instance, Microsoft products, there's a provision in most contracts that says that they can ask you to audit your environment anytime, or worse, they can enter your offices at any time and inspect your facilities, your records, and your systems to make sure that you're still compliant. And so the publishers will tell you, or the third parties will tell you, look, they have a contractual right to audit you. They are asking for you to participate in an audit that's less intrusive than what they contractually have the right to do, and you should cooperate, because if you don't, they're going to escalate you to legal or to some other position in the organization that will usually sound a lot scarier. Can you advance to the next slide, please, Anthony? So let's talk about the BSA audits. BSA has, you may have heard them, a lot of radio and television campaigns. They have a Facebook campaign that says, do you want to go skiing? Turn in your employer for software violations, and we may give you a reward that can pay for you to go on a winter holiday. So that's just one example of the many tactics that the BSA uses to attempt to entice employees to turn in their employers for potential software violations. Now, you might be able to guess that there's a pretty big problem with this approach, which is sometimes people have the incentive to create a non-compliant situation, and therefore they are intimately aware of potential violations because those employees who are turning you in have created those non-compliant situations. So the BSA claims that it doesn't reward people who were responsible for or who in their job were supposed to be making sure that you're compliant, and we want to make sure that we are informing any BSA auditors about the identity of your people who are charged with that responsibility, because we want to make sure that those wrongdoers or those people who are creating non-compliant situations in your organization are not getting rewarded. Now, the BSA claims that they could get up to $1 million in reward money. That's typically not the amount of money that the disgruntled employee or ex-employee may get, but it's something that we want to make sure that we're keeping an eye on. Another thing I wanted to let you know is that the BSA and its law firms that operate all over the country to help them enforce the copyrights of the software publishers will never agree with you and never tell you who your informant is. And so sometimes it's a little difficult to make sure that these people are not getting rewarded simply because they'll never confirm the identity of your informant. Anthony, if you could move to the next slide, that would be great. I wanted to talk to you about some of the published fines. This is a chart from 2000 to 2010. You'll see how many published fines the BSA had. So starting in 2002, you only saw news articles about $1 million in fines, and you can see over the 8 years between 2002 and 2010, there were considerable increase in the fines that these companies that are listed below had to pay, and you'll see the amounts of the penalties that folks had to pay. Now, in a BSA audit, this is one of the most controversial parts of the audit in the resolution that I have to deal with, is are we going to let the BSA publish the penalty or not? My typical approach is that we should not allow the BSA to publish the penalty for the reasons that you can see here, looking at Red Bull having to pay $105,000. What we want to do is make sure that the audit company, the company that's being audited by the BSA, understands that if you want confidentiality, it's going to cost extra. Anthony, you can advance, please. So what we want to do is make sure that regardless of who the auditing entity is, whether it's the BSA or the SIIA We are aware of what the incentives are for the auditors and make sure that we understand what their relationship is with the software publishers, because that can help us in the long run respond aggressively to the audit and make sure that we're not jeopardizing or increasing your potential legal exposure by not understanding what the motivations are for the auditors. So the BSA and the SIIA, which again is the Software and Information Industry Association, they both represent the software publishers, and they're paid to do that. And so there is no argument or no assertion that these folks are independent at all. They are definitely standing in the shoes of the publisher, and they're going to interpret every single question in the light most favorable to the publisher. One thing I wanted to point out about the SIIA is that the SIIA is in competition with the BSA because they have the same members, and so it is not uncommon to get both a BSA audit and an SIIA audit, because your informant might want to go reward shopping and turn the company into more than one auditing entity. In that case, there are things we can do, and you can advance the slide, Anthony. There are things we can do to get rid of one of the audits, at least for the publishers that overlap. So regardless of whether you have a trade association audit like a BSA audit or an SIIA audit, or whether the publisher is auditing you either directly or through an accounting firm, there are many legal issues that arise in these audits across the board. So it doesn't matter who's auditing you, you're going to have to deal with some of these issues when you're deciding whether or not and how you want to respond to the audit. Number one, if you refuse to participate in the audit, the publishers could have a claim that you breached your contract because you had a contractual obligation to allow them the right to audit and you refuse to do so. If there is an over-deployment or a deployment without the ability to demonstrate a license, then you may have a copyright infringement claim. If you have acquired a company that doesn't have the appropriate documentation to demonstrate that they had the ability to transfer licenses to you, there could be a problem with successor liability that results from that merger or that acquisition. So in other words, if you buy a company and they say we're transferring to you 100 computers with all of the licenses on them, you're going to have trouble down the road because all of the licenses on those 100 computers were not identified, and there wasn't any independent demonstration that the company had the ability to transfer those licenses. So if you get audited, it is not good enough to say, we got these licenses from the predecessor company. You have to say, we got these licenses from the predecessor company, and here are the documentation. Here are the documents that are ancillary to that transaction that show exactly what licenses and the quantities we purchased from the predecessor, and here's the documentation that demonstrates that the predecessor had the ability to transfer those licenses. And one thing that's really shocking to a number of companies is because there is a separate claim for contributory copyright infringement, and the bar is pretty low for how to assess liability for contributory copyright infringement, because there is a separate claim for that, officers and directors can be held liable for corporate copyright infringement without piercing the corporate veil. And so whenever we talk about what hammer do the software publishers have in these audits, it's the threat that if you don't cooperate and you can't demonstrate that you're compliant or otherwise resolve the lack of compliance to their satisfaction, they may choose to pursue not only the company for copyright infringement, but the people who had the ability to control the copyright infringement and who had the ability to benefit from it for individual liability as well. Next slide, please, Anthony. So one of the things that we try to do when we're working with companies who are responding to software audits is identify for those companies the common mistakes that people make and try to help them avoid making those mistakes in their audit. Many of the common mistakes that we see are just due to the fact that you have a business to run. You're not in the business of responding to software audits. So it is commonly the case that in an effort to be transparent, in an effort to seem cooperative, and an effort to make sure that no one gets mad at you, the people who are responding to the software audits make inadvertent mistakes that increase their exposure. So the first mistake we see is that companies who receive an audit notice don't push back and identify, make sure they've narrowed the scope of the audit procedure. The executives and the governance committee sometimes have a reliance on the IT staff to identify the deployment information, and many of the automated tools that are available don't delineate between certain types of installations. And so I'll see someone run a land sweeper report or a snow report. It will be completely inaccurate. They will submit that to the other side, and the other side has no choice but to rely on the information in the automated report to make a demand. And so one of the things we try to do is make sure that we're not relying solely on discovery tools. We're also conducting an independent validation to make sure that the tools are reporting correctly. It is important to make sure you understand what documentation demonstrates a license. It is commonly the case that we have folks who come to us with the boxes or the CDs, and they say, look, here's our license. For software audits, this is going to be insufficient. You need something with a date on it that will be acceptable to the other side. A lot of times people have a delay in between the time they receive the audit notice and the time they produce the audit results. You have to make sure that you understand that this is a point in time, and you are only supposed to produce the installations that were in effect on that date. So a lot of times what happens, you get an audit notice in January, you respond in July with the then current environment. Any of the purchases that you make that you produce receipts for between January and July are going to be disregarded because those were after the effective date of the audit. And so you'll have installations that didn't happen until after January, as evidenced by the documentation that you're submitting, and those installations will be counted against you, but your entitlements will be rejected. Finally, the most egregious thing we see and the most common thing we see is people get the audit letter and then start buying software immediately. This is not going to help. So make sure that you understand what the consequences are of scrambling to buy the software products after you receive the letter. Next slide, please, Anthony. So what do you do when you make those mistakes? You have to look and see how the organization is impacted, and I've included a little chart here just to give you a sense of what's happening during the software audit. For a typical company of 100 computers or more, the audit takes somewhere between 12 and 18 months, and you'll see that it affects basically every single facet of the organization. So senior management, legal, IT, finance, procurement, even if you're in a smaller organization and you have multiple people that are performing, or you have one person performing multiple of these roles, you'll see that there are a lot of different negative impacts of the audit and the audit response. People get unhappy. They have to direct resources to something no one has time to do. There might not be a budget for paying for a software compliance issue. You have to spend time searching for documents that could be 20 years old. And you have to help manage the process so that you can make sure that you're not getting sued, that the officers and directors aren't getting sued, and that finally you get a resolution that actually resolves the issue. I have a lot of clients who are consuming IT services, and they tell me, well, I'm going to resolve this, and then after we get the settlement, then we'll go back and buy the software that we need that we haven't told them about yet. What I like to do is make sure when you're making a purchase to resolve compliance that you're resolving all of the compliance issues at once, so you don't have anything popping right back up after you resolve the software audit. Next slide, please. So what can you do? I'm going to skip this slide, Anthony. What can you do to help you defend an audit? So first of all, we're going to, and I think this is an animated slide. Anthony, you can go ahead and animate it all the way to the end to produce results if you like. So what we do is, sorry, it's the settlement is the end. The software discovery phase, I mentioned that briefly. What we can do is go through, use the tools that you have in place to identify what's installed, and then make sure that you're validating the installations to determine that everything that the tool says is installed really is installed, and it was installed as of the effective date. So the proof of purchase analysis includes getting from your vendors all of your spreadsheets of your software purchases, making sure that you're only including purchases that are relevant to that particular audit. Make sure you're analyzing the date and the entity to ensure that what you're about to produce is the right information. It is sometimes the case that we have clients who produce documentation from their vendors that show all of the affiliated entities, and those entities were not included in the scope of the audit until my client produced documentation that showed that they were all connected. So you want to make sure that you're only narrowly tailoring your response to respond to the particular question that's been asked. Before you submit anything, I recommend that you perform a gap analysis where you compare what you have installed on the effective date versus what you can prove you owned on the effective date, so that you can get a sense of what your potential financial exposure might be. You want to make sure that you are aware of what number is going to be before you submit it, because if your exposure, for instance, is $7 million, you may choose not to participate in the audit voluntarily. Once you're comfortable with producing the audit results, get a confidentiality agreement and then produce them. That will start your negotiation process, which hopefully, if everything goes well, will culminate in a settlement. Next slide, please. So the software discovery, as I mentioned a moment ago, this is critical to success. Sometimes the reporting is unreliable, the validation is difficult, and somebody who has experience responding to auditors really needs to analyze this data before you produce it to the other side. Next slide. With respect to the proof of purchase documentation, you want to make sure that everything has a date. It has the company that's being audited identified somewhere on the sheet. You can use packing slips and those other things. You can't use quotes unless you show a canceled check showing that you paid for the quotes. And to the extent that you can outsource this work to your vendors, calling up Dell, calling up CDW, and asking them to produce a report of your purchases, very helpful. Next slide, please. Then you want to do your reconciliation or your gap analysis. Make sure that you understand the appropriate downgrade rights. I have people all the time tell me, well, I have 2016 licenses for Office. They're box licenses. I should be able to use those for my 2007 installations. If they're not volume licenses, you cannot use them for your installations. So if you've produced the material showing you have 2007 installs and 2016 licenses, you're going to have a problem. So make sure you understand what the implications are of each of the software comparisons before you produce your materials, and the best way to do that is to perform a gap analysis. Next slide. So once you've done all of that and you're about to produce your audit materials, make sure you're organizing them in a way that makes sense. You don't want the other side, when they're counting, to have to dig to identify what goes with what. And as I mentioned, you want to make sure that you have a Federal Rule of Evidence 408 agreement, agreeing that anything you produce cannot be used against you if you're unable to come up with a resolution. You also want to make sure that you obtain management approval before you submit audit results. So a lot of times what happens is the IT staff gets an audit, they say, we don't have anything to hide. They prepare the materials, they send it, they get a $3 million demand, then they go to legal and management and say, I think we have a problem. And many of the problems that arose in that audit could have been avoided with management and or legal involvement at the outset. Next slide, please. The negotiation, we need to make sure that we're challenging any legal arguments that the other side is making. For instance, the calculation of damages. We want to make sure that we review carefully what the auditors found was installed to make sure it matches our expectation. And we want to make sure that we understand that there are both monetary and non-monetary provisions in a settlement agreement that have to be addressed. Next slide, please. The settlement should include a complete release of liability. I can't tell you how many times the publishers have come up to the business team as part of an audit and said, hey, we can give you a much better deal if you don't insist on this release thing. And people are always baffling me when they enter into a resolution that does not contain a full and unequivocal release. We never ever let the software publishers come in and inspect, or their trade associations come in and inspect to make sure that we're still compliant. We have to make sure that they're not imposing additional licensing terms in the settlement agreement. Sometimes they try to sneak that in. And as I mentioned before, confidentiality is an important consideration, but it may cost the company a little extra money. Next slide, please. All right, so I think I finished with just a couple of minutes to go. And Anthony, if I'm not sure if we have time to take questions, but if we do, I'd be happy to answer one or two.
Yeah, we do have a couple of minutes left. If anyone has any questions, feel free to ask right there in your chat window along the side, and we'll definitely review those. And while we're waiting for a couple to come in, one question that I have is within acquisition, or when you mentioned acquisitions and mergers, you mentioned what is the best way for the purchasing entity to gather all of those requirements for documentation on the licensing?
That's an excellent question. The best way to do it is, number one, have a schedule of software in the transaction document. So instead of saying that, if people are really good about including a schedule of hardware and saying we're buying 37 HP laptops. Instead of just saying that, if we can instead include a provision that says we're buying 37 HP laptops, each of which has Windows operating system on it, this version, this edition, it has Windows 8 Pro, and also has the Office Suite, and we represent and warrant to you that we have the ability to transfer those software licenses. So that way the onus is on the company being acquired to investigate and make sure that there's the ability to transfer those licenses. Additionally, you want to make sure that if, for instance, you are trying to transfer an Oracle license, you have to actually give Oracle notice and get Oracle's permission before it becomes effective. And so you want to make sure that you understand all of the responsibilities for getting a license officially transferred and which company is going to undertake completing that paperwork. Because sometimes they'll go through all of the steps and forget that last part, and forgetting that last part will result in not having valid licenses after the transfer.
Sure, yeah, and that's one thing that we see when an agency acquires another one, going through, and their asset list really that is part of the purchase agreement is X amount of computers and servers, and that piece is usually left out. So then it's a lot of legwork on our end to go through it, and sometimes, unfortunately, we have to tell the agency that there's going to be some more money that needs to be spent just to get those licenses up to date to avoid any hassle and headaches in the future.
Yes, that's an excellent point. I see that regularly where people don't have all of the documentation they need even though they paid for the value. So now I have some companies that absolutely refuse as part of a transaction to even purchase licenses. Instead, they'll just say, we don't want any of your licenses, and so we're not going to pay you in the transaction the value of those licenses because those aren't valuable to us. Mm-hmm. So we're not going to do the investigation. We're not going to try to transfer the licenses. We're simply going to say no software licenses are being transferred, and we're taking out the value of the licenses from the purchase price. Sure.
And it's definitely one of those unexpected but necessary costs to purchasing and then also running businesses as well.
Absolutely.
I don't see any other questions out there. I did list Julie's contact information. It is up on the presentation here. We are recording this, and it will be posted to our YouTube channel. So if anyone that you want to share this with inside your organization or other members, it will be posted there and available for viewing later on today or tomorrow morning at latest. I do ask if you do have any questions, feel free. Julie, I'm guessing they can reach out to you.
Absolutely.
Always more than welcome to reach out to us as well.
Thank you guys so much for this opportunity. I've really appreciated working with you today.
Thanks, Julie. Definitely appreciate your time.
Have a good day.
Everyone have a good rest of your day. Thank you.
Thank you all. Bye.